For 14 straight months, I let my homeowners association charge me $40 every single day. I never paid 1 cent. I never called to argue. I never walked into a single board meeting to defend myself. I simply let every fine stack higher because I wasn't trying to win an argument. I was quietly building what would become the biggest lawsuit that HOA had ever faced. Before we go any further, I want to know where you're watching from. Drop your country in the comments because I always enjoy seeing how far these stories travel. And if you haven't subscribed yet, now's the perfect time. Hit that subscribe button because this story only gets more unbelievable from here. My name is Daniel, and 3 years ago I purchased a modest 3-bedroom home in a peaceful subdivision just outside Charlotte. The neighborhood looked picture perfect. Clean lawns stretched across every property, tree-lined streets stayed quiet all day, and there was even a community swimming pool that hardly anyone ever used. It felt like the kind of place where nothing unexpected could happen. What I didn't realize was that the Homeowners Association was controlled by a woman named Carol Whitfield, and she ruled the neighborhood as if it belonged to her personally. Mailbox paint starting to peel? Fine. Grass even half an inch above the limit? Fine. Christmas decorations still hanging after January 2nd? Of course, another fine. During my first year there, I played by every rule. I paid my dues on time, kept my hedges perfectly trimmed, and forced myself to smile through board meetings I never wanted to attend. Everything changed one spring morning when I found an official violation notice taped to my front door. According to the HOA, my detached garage, the same garage I had legally built with permits 2 years earlier, was suddenly violating newly updated setback requirements. Confused, I immediately called the HOA office. The woman who answered calmly explained that the board had recently revised the neighborhood bylaws. Recently meant 4 days earlier. Recently meant the timing lined up perfectly with my property. Recently meant someone had created a rule that seemed designed specifically to target me. That was the moment I knew something wasn't adding up. I requested copies of the meeting minutes showing where the new rule had been approved. They delayed their response. I asked for the official voting records. More delays. Instead of providing documents, they kept mailing violation notices. $40 every single day beginning immediately for a garage that had been standing legally for 2 full years. Most homeowners would panic. They would write a check, tear down the structure, or spend thousands of dollars fighting an HOA backed by community dues and expensive attorneys. I chose a completely different path. I paid absolutely nothing. I didn't complain. I didn't negotiate. I simply watched the fines grow larger day after day and week after week, while I quietly did something the board never imagined. I documented everything. Every violation notice. Every date stamp. Every phone conversation legally recorded with consent. Every email where board members contradicted each other about which rule I had supposedly violated. By the 3rd month, the fines had climbed past $3,000. My neighbors thought I had completely lost my mind. One woman even warned me that the HOA could place a lien against my house. "You should just pay it," she told me. "Nobody beats the board." I just smiled and answered, "We'll find out." Because there was one thing nobody in that neighborhood knew yet. The discovery that would eventually blow this entire case wide open in court. I hadn't been ignoring those fines out of stubbornness. I had uncovered something hidden inside the HOA's own records that Carol Whitfield desperately hoped no homeowner would ever discover. But before I reveal what I found buried inside those documents, the evidence that turned this entire case upside down, you need to understand just how far this board was willing to go. By the 6th month, the accumulated fines had passed $7,000. They mailed me a formal letter threatening foreclosure through an assessment lien. They posted my name on the community bulletin board as a homeowner who refused to comply. They even spent a neighborhood summer barbecue trying to convince my neighbors that I was the problem. I stayed silent. I stayed patient. And I kept gathering evidence the way a squirrel stores food before winter, knowing the day would eventually come when every piece would matter. Because what I had uncovered wasn't some harmless paperwork mistake. It was proof that Carol Whitfield had broken the law before she ever fined me. Here's what happened. North Carolina, like many other states, requires HOA bylaw amendments to be approved through a formal vote after proper notice is given to every homeowner, with the results recorded in official meeting minutes. As a homeowner, I exercised my legal right and requested those records. It took 4 months, along with 2 formal written demands, before they finally handed anything over. What they produced was the smoking gun. The updated setback rule that supposedly made my garage illegal had never been approved by a vote of the full board. Carol had quietly inserted herself through a private memorandum just 3 days before issuing my very first violation notice. She had manufactured legitimacy for a rule that legally did not exist. I immediately hired a real estate attorney who specialized in HOA litigation. After reviewing the timeline, the fabricated rule, the fines issued before any lawful approval, and the public retaliation against me, she leaned back in her chair, looked me straight in the eye, and said, "Daniel, they didn't just break their own bylaws. They violated North Carolina law, and you have the evidence to prove it." My attorney looked at me and said, "The strongest part of your case isn't just that they broke the law. It's that you've documented every single day they kept doing it." That was the moment I stopped defending myself. Instead of responding to another violation notice, I filed a countersuit, not simply against the fines, but against the entire HOA board for fraudulent rulemaking, harassment, and violations of North Carolina's Homeowners Association laws. The court hearing wasn't scheduled until 8 months later. When the day finally arrived, I walked into the courtroom carrying a folder nearly 3 inches thick, packed with evidence. Carol arrived with an attorney who looked completely confident, as if this would be nothing more than another routine HOA dispute. Their lawyer spoke first. He described me as a homeowner who had deliberately ignored the rules and accumulated more than $10,000 in unpaid fines. Listening to him, you'd think the outcome had already been decided before the hearing even started. Then my attorney stood up. She placed Carol's so-called bylaw amendment, the fabricated memo, on the courtroom projector for everyone to see. Next, she displayed the official meeting minutes, proving there had never been a board vote authorizing the rule. Then she played one of my recorded phone calls. On the recording, the HOA's own office administrator admitted that the setback rule wasn't something the board had approved at all. It was simply a rule Carol had decided to add herself. The judge's expression changed almost immediately. Carol tried explaining that she believed she had temporary authority and broad discretion as board president. She stumbled through one justification after another, but none of it mattered. North Carolina law couldn't have been clearer. Changing HOA bylaws requires a properly documented vote. No exceptions. Then my attorney introduced the second major piece of evidence. She presented photographs of the community bulletin board where my full name and home address had been publicly displayed under the label non-compliant resident. She argued that the posting wasn't about enforcement. It was intentional harassment and public humiliation, violating protections provided under the state's Homeowners Association laws. The HOA's attorney immediately objected. The judge overruled him without hesitation. I watched Carol's face slowly lose its color as the judge carefully reviewed my evidence. Page after page. 14 months of documented violations. 14 months of detailed records. 14 months of silence, patience, and careful preparation. Every single page had led to this moment, and it was finally about to pay off. Literally. The judge didn't need much time to reach his decision. He ruled that every fine the HOA had issued against me was legally invalid because the rule they claimed I violated had never been lawfully adopted in the first place. But the ruling didn't stop there. The court ordered the HOA to reimburse every dollar of my legal expenses. The judge also awarded damages for the harassment and defamation caused by publicly posting my personal information on the community bulletin board. Then, after finding that the board had knowingly enforced a fraudulent rule in bad faith, he imposed additional punitive damages. When everything was totaled, the HOA was ordered to pay me just over $31,000. The same association that spent over a year trying to force me into paying roughly $8,000 in fabricated fines ended up writing me a check nearly 4 times that amount. Carol Whitfield resigned from the board just 2 weeks after the judgment. The newly elected board wasted no time. Its very first official action was repealing every bylaw and restriction Carol had quietly inserted over the years without a lawful vote. As for my garage, it's still standing exactly where it has always been. No violations, no fines, no legal questions. Completely untouched and completely lawful. Looking back, I learned something that most people never realize. Sometimes the smartest response isn't to fight immediately. Sometimes the winning strategy is staying calm, staying patient, documenting everything, and allowing the people abusing their power to create the evidence that eventually destroys their own case. And believe me,